After receiving the summons in the complaint, whether the first complaint or the 15th complaint, the defendant has 21 days to answer or otherwise respond to the complaint. If the defendant wishes to have the case or any portion of the case dismissed, the proper response is to file a motion to dismiss under Rule 12 within the 21-day deadline. However, if the defendant wishes, he can file his answer and raise these objections in his answer. The rules there become a little bit more complicated and probably beyond what you're going to have to know for your first year civil procedure course. Rule 12 is long, but pretty important. I recommend you scan it for yourself. Rule 12b sets forth the types of motions to dismiss that the defendant may file. 12b1, dismissal for lack of subject matter jurisdiction. We're going to go through all of these in more detail in a minute. 12b2, dismissal for lack of personal jurisdiction. 12b3, for improper venue. 12b4 for insufficient process, and 12b5 insufficient service of process, and we'll discuss the difference. 12b6, failure to state a claim, and 12b7, failure to join an indispensable party. Additionally, Rule 12e requires the filer to clarify a misleading or ambiguous pleading. This only applies if the pleading is so poorly drafted that the defendant really can't respond to it. Rule 12f allows the defendant to ask the court to strike a pleading that is redundant, irrelevant, or scandalous. It's rather rare. By filing a Rule 12f motion, the defendant waives his ability to make certain Rule 12 motions in the future that were not presented in the first Rule 12 motion. The types of Rule 12 motions that are subject to waiver are 12b2, lack of personal jurisdiction; 12b3, improper venue; 12b4 and 5, insufficient process and insufficient service of process; 12e, failure to clarify a misleading or ambiguous pleading; and 12f, to strike a pleading that's redundant, irrelevant, or scandalous. Again, all of those are waived if they're not raised in the first Rule 12 motion. Might be easier to remember the ones that are not waived. Those are 12b1, dismissal for lack of subject matter jurisdiction. If you recall, subject matter jurisdiction is never waivable. 12b6, failure to state a claim. The complaint is deficient. Can't waive that. And 12b7, failure to join an indispensable party. To illustrate, Harry files a 12b6 motion arguing that the complaint is inadequate. By so doing, he has waived his ability to object to personal jurisdiction, service, that the complaint is ambiguous, or that the complaint is scandalous. But he has not waived his ability to object to subject matter jurisdiction, failure to add an indispensable party, nor has he waived his ability to file an additional 12b6 motion on an unrelated issue. So whenever you see a motion to dismiss, you should immediately think about waiver and ask yourself whether what arguments the defendant has waived by failure to raise them in the first Rule 12 motion. So let's go through a couple of these, see how they work. Elaine, residing in New York, sues Jerry, also residing in New York, in the federal court in South Dakota. Jerry argues that there's no personal jurisdiction in South Dakota. He's never been to South Dakota, never wants to go to South Dakota. So he writes a nasty letter and seeks to have it published in the New York Times. He then complains about it with George and Kramer for the next 20 minutes, talking about South Dakota. Nothing's really happened, for our purposes certainly. He's still required to appear in the federal court in South Dakota. So what does he do? How does he get out of the court in South Dakota? Well, he files a Rule 12b2 motion in the court in South Dakota, arguing that that court doesn't have personal jurisdiction over him. While he's at it, he does, and certainly should, and if you don't see this on your exam, you should raise the point, make any additional Rule 12 motions that he can, keeping in mind that failure to raise them at the first point, that is the first Rule 12 motion, is waiver, with regard to at least some of them. We went through that list before. If a defendant files a 12b3 motion to dismiss for improper venue, the court will either dismiss the case or transfer it to another venue. Generally, if there is a U.S. court that would be a proper venue, the local court will transfer the case to the other U.S. court. If, however, there is no U.S. court that would be a proper venue, but there is a foreign court that would, the local court will likely dismiss the case and allow the plaintiff to refile in the overseas court. A 12b4 motion for insufficient process relates to the form of the summons. Essentially, the defendant is claiming that the summons does not comply with Rule 4a or otherwise violates constitutional requirements. Now, because the court usually issues these summons, 12b4 motions are quite uncommon. A 12b-5 motion for insufficient service of process, on the other hand, claims that the plaintiff did not adequately serve the defendant, did not follow the rules of service that we discussed previously. 12b-6, failure to state a claim, means that the complaint doesn't contain all of the necessary allegations to support one or all of the plaintiff's claims.